where Mr. Hamilton says, I'm aware several NHS trusts have pharmacy manufacturing units to compound Avastin in order to make it available for ocular use. These have included Portsmouth, Queen Alexandra Hospital, Portsmouth, the Royal Liverpool and Broad Green University Hospital NHS Foundation Trust, the Royal Free Hospital and the Wirral University Teaching Hospital NHS Foundation Trust. So 4 hospitals are named there. These NHS bodies have invested many millions of pounds in developing these facilities, and I stress those words, and regularly supply other NHS bodies with compounded Avastin for use for a range of ocular patients, including wet AMD patients. That's what's come to be known as Mode 3 supply. I'm aware of at least one commercial organisation, ITH Pharma, that undertakes a similar function. That's what's being called Mode 4, because it's coming from a commercial provider. Then dropping down to paragraph 33, the position taken by the CCGs is that our provider NHS Trust should be placed in exactly the same position as other organisations providing ophthalmic hospital care in the UK. Namely, they should be entitled to source a supply of compounded Avastin from a reputable source, just as other NHS hospitals and private hospitals are able to do so. Turning over, then I think it's just worth looking at paragraph 35. The final sentence: I do not see why patients in the North East should not be able to access the same drugs in the same way as other parts of the NHS have accessed them for several years, and access the same drugs which have been provided to the private sector. Now, there are disputes about the accuracy of all of that, but that doesn't matter. For present purposes, the court will appreciate I'm showing you that evidence because it makes good the point that what was envisaged when the policy was drafted was plainly supplied through modes 3 and 4. And there's a further point that we make in relation to mode 2, which arises from this evidence, which is that none of the hospitals that Mr. Hamilton identifies in his evidence as having, and I quote, invested many millions of pounds to develop facilities required to produce CV are funded by the CCGs. None of them are within the CCG's areas. The reality is that there are a small number of sites capable of attempting to produce biological medicines safely and at scale according to the applicable quality standards. And there's no suggestion whatsoever in the CCG's evidence that hospitals within their purview currently have such facilities. And if I could just briefly explain why this led Novartis to make the Freedom of Information Act requests, which they did, and which have led to the new evidence. What happened was that at the hearing below, Mr. Locke said that all of the 5 trusts have the ability to compound on site, and he referred in particular to Newcastle and South Tees being massive hospitals who are perfectly able to do the work for themselves. And the relevant transcript passages are in the bundle. Now, no doubt they are massive and indeed excellent hospitals, but what the evidence shows is that none currently have the requisite facilities. So the 2 hospitals that Mr. Locke highlighted, South Tees answered the FOIA request by saying they didn't possess the
Well, hang on. This is referring to the evidence whose admissibility is not.
So I'm I suppose showing your lordships and your ladyship how some of that evidence comes in.
Well, I'd better just check, Mr. Locke. You were, I think, content that we see what the evidence says de bene esse, rather than have to rule on its admissibility now. That does seem the sensible course.
Subject to one caveat, which is rather important. which is that the fact that in-house hospital compounding was one of the modes of implementation was set out very clearly in our summary grounds. So it has been part of the...
So sorry, wasn't asking you to make a point about the substance of the Stafford submission. It was merely about the fact that she was referring to the evidence which has not yet been allowed to be
I don't
admitted.
object to her Debeni-Esso. I don't agree with its characterisation, but I can deal with that in response. But I don't
Well,
raise
that's
no
helpful,
objection.
thank you. Well, there you go, Mr. Stafford.
Yeah, I'm just explaining why that evidence was produced, why it became relevant. It couldn't have been relevant before because it arose out of matters that came up at the hearing. So South Tees said we don't possess the requisite facilities. Just for your note, I'm not going to go to it, but Unagreed Bundle 2, page 72, and Newcastle said it had no plans to manufacture compounded bevacizumab. Unagreed Bundle 2, page 101. The correspondence is all summarised in Mr. Kelly's first witness statement at paragraphs 11 to 24, and I don't need to say any more about it, but we do maintain our submission that Mode 2 is all, therefore, hypothetical and is devised to obtain a declaration that the policy is lawful, after which the realistic modes of compounding, namely 3 and 4, can be pursued. So, when Mr.
Not
Locke
if this
says
court has ruled that they're unlawful.
the court has ruled that they're...
Not if this court has ruled that they're unlawful.
Indeed. Indeed, I'm grateful. But I'm still on ground one at the moment, so I'm trying to set the framework for what the questions and the approach that we say the court should be taking. And Mr. Locke may say that Mode 2 was raised in a general hypothetical sense in the pleadings, but our point is a factual one about what the NHS trusts within the CCG's area could actually do, and therefore what, if they did want to supply through Mode 2, the scale of the investment, the many millions of pounds that Mr. Hamilton refers to, that they would have to invest to do that, would, we say, render this a completely different policy with different costings.
Let us assume for these purposes, though I appreciate it's not your case, that Mode 2 is lawful, but Modes 3 and 4 aren't. And suppose the policy had said, Avastin, if you can obtain it, should be the treatment of choice. I'm paraphrasing what it says now. But we leave it up to you to see how you can obtain it lawfully. Might even have said, if you're correct, it may require substantial investment by one or more of the hospitals within the group which this group serves. Would that be unlawful?
Well, it would be a very different policy. So,
But I'm just testing what makes this policy unlawful. Is it the fact, assuming Mode 2 is lawful, that it doesn't spell out the practical difficulties or the fact that at the moment they're not in a position to obtain it?
I would go further.
Lawfully.
It's not just that it doesn't spell it out. It's not just silent. It's that a policy with these figures in it cannot be contemplating Mode 2.
No, but
That's our point.
I was putting to you
Yes, I'm sorry.
that if there was I just want to isolate where the unlawfulness lies in the policy. If the policy made general observations about the safety and comparative cheapness of Avastin and equal effectiveness of Avastin, and said that and encouraged, to use your word, trusts to prescribe it, and made it clear that the only lawful way in which it could be provided was by in-house production, and left it up to them whether they could achieve in-house production, would such a policy be unlawful?
on the assumption that in-house production is lawful, which of course we
Yeah.
don't accept, but on that assumption, I don't think we could then say that was unlawful.
No, I rather thought that's what you would say. So,
Yeah.
what if it doesn't say anything either way and says nothing to... What if it doesn't say anything either way, but does not contain the language to which you attach importance, which you say is only reconcilable in practice with it being modes 3 or 4? That's to say, with bulk external supply.
Well, we would still be construing it purposefully, so other materials that we've been looking at which show, in my submission, the true meaning of policy, we could still look at.
Not necessarily. The trusts to which it was provided would have to take their own advice as to how they were going to get Avastin.
And we need to be realistic, my lord, about the scale of the demand that this policy like this would be creating, and therefore what it would call for.
Do we have evidence about that? Something
like 20,000.
I can give you, my lord, the figures. There are 1,400 new patients approximately every year. They require approximately 10 injections for a course of treatment. So that's 14,000 injections just for the 4 hospital trusts in question. You get that basic figures from
40,000 a year.
14,000 a year.
Okay.
The entire output of the Royal Liverpool in 2010 was 7,000 injections. So my answer to my lord's question would be, if a policy creates a demand which it can't supply, with all the patient disruption and patients consequently being switched from medicines due to shortages because it can't be sourced internally, it's unlawful.
Is there somewhere written down how a patient is treated with this? I mean, you say there's new patients. Do they have to have this 14 injections every year, or is there somewhere where it's conveniently set out how it's administered? Where is that?
It's in the MHRA review.
Yeah.
My understanding, my lady, is you get an injection once a month for about 3 or 4 months, and then it switches to bi-monthly injections thereafter, and it continues after the first year as advised by the doctor.
That may well be the case for Mr. de la Mare's client's product. There are slightly different regimens for the two products, and it's all set out in the SMPC, which of course is part of the marketing authorisation. We haven't got the SMPCs. I
Yes,
think
we
I'm right in saying it. Have we in the bundle?
Yeah.
No.
One of them is.
We've only got the Avastin SMPC.
Also, can I just rise my feet to correct the figures? Page 619 of Bundle 2, the original appendix, the report.
Sorry, 619 of what bundle?
Of Core Bundle 2, Core Bundle B, 18A, the figures appear in the first paragraph on page 619.
Yeah, that's the policy itself.
20,000 cases a year in England and 1,379 for the northeastern Cumbria, which is the region that we're concerned with for those 12 CCGs.
So you multiply that by 10. That is indeed the number I was referring to, my lord. You get the 1,400 number by multiplying that by 10, which is the approximate number of injections required. 40,000, sorry.
Do we have anywhere an account of the facilities that you need in order to compound either on a one-off basis or on a bulk basis? Is that simply set out factually in some witness statement?
Yeah, Mr. de la Mare is going to deal with that.
Okay, well I won't anticipate it. Thank you.
I'm grateful. My fifth and final context point is that there are points arising from the way in which the CCG's arguments have developed over time in these proceedings. And as the court has already stated, I understand the case has developed a long way from what was originally put before the CCGs and adopted in policy. So the whole concept of modes 1 to 4 delivery is lawyer and litigation driven, and I'm not making a technical or a pleading point here. It's just that this was a new and lawyer-driven way of presenting theoretical ways in which the policy could be implemented. Mode 1, I know that your lordships and your ladyship have the point. That indeed came as a complete surprise to us and our clients when it was at first posited as a hypothetical means of implementing the policy. I've shown the court the evidence that we say makes plain what was in the minds of both the authors and the addressees of the policy at the time it was adopted, and we say that was plainly modes 3 and 4. We've seen paragraph 30 of Mr. Hambleton's statement, which proceeds on the basis, we say that supply will be modes 3 and 4. And we don't see anywhere any suggestion that modes 2 or 1 will be used. Indeed, Mr. Ray, Andy Ray, one of the CCG's witnesses, explicitly acknowledges that the original proposal was to use what he calls compounded Avastin. And there are a number of other candid acceptances along those lines. Where all of that gets us, we say, is that the legality of the policy must stand or fall with the legality of modes 3 and 4. And we do say that those are the only modes which are consistent with the level of savings used to justify the policy, and are the modes which were envisaged at the time. Before I move on to my final broad head of submission, which is errors in the application of the test, I do just want to flag, this is in our skeleton, so in the interest of time I won't develop it, but we do make a more general point that if the judge is right, we say that has undesirable implications both for public administration and for the efficient conduct of judicial review. And those points are developed at paragraphs 27 to 29 of our skeleton. Where does all that leave us for this claim and this appeal? We've been clear throughout, and there are passages that make this clear in our first instance skeleton, that the legality of this policy must stand or fall with the court's finding as to the legality of what was in contemplation when it was adopted. So we say modes 3 and 4. But, and I do need to stress this, we also expressly recognised below, and we continue to recognise, that in determining the issues and deciding whether the policy is lawful, the court will consider issues relevant not only to CB, but also to original vial use. And we acknowledge realistically that original vial use could form the basis of a fresh policy. So the claimants have never objected to the court making findings which could inform a future policy. But what we do say is that cannot save the current policy. Finally, my last broad head of submission, we say even if Mrs. Justice Whipple's articulation of the test was accurate, that test wasn't properly applied. Well, just to cover off all of the modes, first, for reasons we've explained, we say objectively and purposely interpreted its policy for supply under modes 3 and 4, and those, for reasons that Mr. Delamere is going to come to, are unlawful. Turning to modes 1 and 2, we submit neither of those modes are realistic ways of implementing if the policy is properly understood in its context. It couldn't be based on mode 1 because bevacizumab supplied through original vial use would cost much more, and the court has that point. And so, we say, would be the cost of mode 2. So we say also that those are not realistic modes of implementation. And then we make another separate point at this stage in our skeleton, because it's where we pick up judges' finding that even if an NHS trust purchases CB from an established commercial market that is, and I'm quoting now from the judgment, built on repeated breaches of EU law, the trust is not necessarily breaching EU law. That's paragraph 232, subpara 2 of the judgment. And our short point is this: the policy, when implemented, would plainly generate additional demand for CB. And if that supply is, as we submit, unlawful, then the trusts are not in some way insulated from that illegality. This would be a classic case of the policy encouraging or leading to illegality. And the relevant domestic legislation, Human Medicines Regulations 2012, which Mr. de la Mare is going to show the court in detail, do create criminal offences which include procuring, sale, supply, manufacture or assembly of unauthorised medicinal products. So I'm just for now making the simple point that if the policy leads to, encourages or permits unlawful supply, then it is unlawful, and any trust acting upon it would also be acting unlawfully. Those are my submissions.
My lords, my lady, I get the Euro part of the case. My submissions are going to adopt the following structure. The first thing I'm going to do is take you, I fear you'll think at tedious length, through the legislation. I've carefully pruned and thought about each provision I'm going to cite to you. It's going to feel like too many at a time, but each has a purpose. I'm going to take you through the domestic regulations as well, which consist principally of the Human Medicines Regulations, Section 10 of the Medicines Act, which is the gateway through which everything in this case must ultimately pass if it's to be lawful. And I'm going to take you to 2 bits of relevant MHRA guidance and the GPC, the General Pharmaceutical Council's guidance, which is about the lawful use of the Section 10 gateway. Then I'm going to take you through the facts pertinent to how CB is made and manufactured and the quality risks that entails. Because this case, so far as it's about concerns on safety and so far as the issue of modification under the apposite case law arises, is principally about that second topic in the directive, quality, because manufacturing processes may lead to medicines losing their efficaciousness, losing their safety, losing their quality, and therefore becoming not only pointless but actively dangerous. After that, I'm going to take you through the 5 cases that determine the outcome of the EU issues. 3 of them are very short points: Commission in Poland, Corona and ABSA. I'm going to spend most of my time on the cases going through apposite and AIFA very carefully. And then I'm going to go through each of the grounds in turn, setting out the judge's judgment, explaining the positions of the parties and explaining our case. But before I take you on this, no doubt, fascinating tour of EU pharma legislation, I thought it would be helpful to set out certain themes in advance, because they certainly help to make what is otherwise an indigestible menu perhaps a little bit more digestible. The first, and this echoes something my learned friend Miss Stratford has already indicated, is that however you look at it, this policy is predicated on the bulk supply of compounded bevacizumab. It's all about bulk. A little bit of compounding ad hoc here or there will not meet the levels of demand that the policy is intended to create. The policy, on its terms, is intended to switch over 75% at least of new patients to exclusive use of CB. And you'll see that in the policy documents themselves. 70% of new patients. So of that 14,000 dose figure, approximately 11 to 12,000 doses, just in this one set of regional hospitals alone, will be switched to CB. And that's why, if there is any requirement as to a prior prescription, that bulk arrangement also requires bulk provision to whoever it is that's doing the pharmacist doing the compounding of the relevant prescriptions. And that's not just an issue about waiting times, as my learned friend indicated, or extra minutes. It's also the entire system to comply with GPC guidance to ensure that the dispensing or compounding pharmacist has everything that they lawfully require before they commence the compounding operation. That's a topic dealt with in Chapter 4 of the GPC manual that I'm going to show you. So what do you get from this emphasis on bulk? Well, this. One thing that there's absolutely no evidence about was that the policy was set up to operate such a regime of bulk prescription along with bulk supply. Bulk supply is obvious. It's clear from the evidence it was bulk supply. But there's no suggestion that any thought has been given to the logistics of bulk prescriptions, which the Secretary of State, I think, accepts is certainly required for Mode 3 and 4, nor of the potential burdensome problems that might flow from them, including that age-old catchphrase of our times, GDPR, if you're sending NHS data to a commercial compounder. The second thing that flows from this, and this is my second theme, the theme of manufacturing or quality risk, is that bulk supply is predicated upon the use of a specialised, scaled and complex compounding operation that amounts to manufacture. And because it is a manufacturing process, it gives rise to a large number of additional risks relating to the sterility of what is being compounded, relating to the changes to the shelf life of the medicine in question. 2 years is the shelf life for Avastin in a vial. 7 days is the maximum shelf life permissible for an operation of compounding under Section 10. I'm going to show you that. And of course, you're replacing the immediate packaging of the product. That is, you are moving it from a glass vial into a plastic syringe with lubricating oils, all of which, as the MAs and the entire authorization process shows in relation to marketing authorizations, gives rise to risks of chemical interaction with the contents of the syringe, causing loss of effectiveness or worse. It gives the rise to the risks of leaching of the biological medicine into the plastic itself, interaction with the lubricant oils, etc. These are all quality risks that are in no way assessed in the same way that would be assessed under a manufacturing license. And one of the myths I think you're going to have to dispel in this case is that there's something hermetically sealed between a manufacturing authorization and a marketing authorization. The two, in fact, as I'll show you from the regulatory regime, go completely hand in glove, not least because the modes of manufacture and the choices you make as a manufacturer, such as the choice of syringe, the choice of sealant, etc., the choice of packaging, indeed, in certain circumstances, those choices feed into the very thing that is approved in the marketing authorization. So the marketing authorization is an approval of the specific mode of manufacture of the particular item in question by a particular named manufacturer. The two are not somehow completely separate topics. Indeed, as the MHRA said in their document, it's very much the case that the manufacturing setup is part of the design of the product approved by the marketing authorization. So manufacturing quality is a key theme in the provisions I'm going to show you. And where that takes you, it seems to me, in relation to what is undoubtedly one of the main topics you're going to have to address in the EU case, is where that takes you to is how do you approach the question of modification? And I think there's a nice way to illustrate.
Sorry, I'm trying to keep up with your themes. Are we
Manufacturing risk is the
Are
theme.
we still on theme 2?
We are. Could you turn up Sup B, tab 23, page 456? This is the MHRA's new statement. And what they've done very, very helpfully here is identify in 3 bullet points the differently grouped concerns that are addressed by the medicines regulation regime through a marketing authorisation. So, point 1 is has been assessed.
Wait. What page are we on?
456. It's the 3 bullets near the bottom. The medicines licensing regime ensures that a licensed medicine has been assessed for safety, quality and efficacy. That is, if you like, that it's safe by design. That this combination of active ingredients and excipients, if properly manufactured and delivered in a high quality form, will not produce adverse effects, etc. That's the classic data package, clinical and preclinical studies. Second point, has been manufactured to appropriate quality standards. That's what I'm banging on about in this second theme, and it interacts with and goes hand in glove with the first theme. And then the third theme is, when supplied, is accompanied by appropriate product information and labelling. And you'll see when we look at the directive is accompanied by requirements for an SMPC to be given to doctors, for particular labels to be applied on the outside of the pack, for the packs to be suitable for wholesale distribution, etc. That's all designed to ensure safety in use. Okay? Now, in relation to the key issue of modification, I would suggest that the issue that you're going to have to decide is where the dotted line exists in this trio. Because our case is that the dotted line exists as between the second and third bullet points. We say it would be nonsensical, given the structure of apposite, if quality was not a matter that gave rise to a modification. If you could show
Given the structure of what? Apposite?
Apposite, the apposite ruling of the CJE.
Oh, I see, sorry, okay.
So the question is, one of the key questions in the case is, what is modification? It's ground 3A. Manufacturing risk, we say, is above the line and constitutes a modification. When we say properly understood apposite is really about second or third order concerns about get-up, labelling and packaging, if you like, the kind of things that arise in parallel importation cases when you do bare repackaging of medicines, and that's the third bullet point. So that's my second theme, manufacturing risk, and you can see, I hope from that, where it goes to in the question of modification. The third theme is this: there is a significant and very important difference between the process of manufacture, which is exhaustively regulated by the directive, both in the marketing and the manufacturing authorisations, and the separate topics of the use and administration of the product already made. Use and administration is about what a doctor or patient does with the medicinal product once it's in their hands. And use and administration is regulated only partly by the directive, insofar as it concerns issues like labelling and packaging. And thereafter, it's for national rules, regulating the practice of doctors, pharmacists, nurses, etc., to control the use and administration of medicines. And now that third theme is relevant, because if manufacture leads to an unauthorised product, that product is then used and administered by a doctor. Whereas bare use and administration of something that hasn't been through a manufacturing process, like single vial use, doesn't give rise to those concerns. And that's the basis in our submission for the difference between mode 1, where effectively a doctor in the clinic sticks the needle into the vial, draws out a portion and injects it directly into the patient's eye. That is use and administration. Modes 2 to 4 all are predicated on a prior manufacturing process. And the fact that the thing, as manufactured and processed, is thereafter used and administered doesn't detract from the necessary inquiry as to the lawfulness of that process of manufacture. And that's not surprising when you think about it, because there's something fundamentally different about the two. When I make a product in the way that compounding envisages, what will happen is the product is got up in the syringe, it's wrapped in a wrapper, it's given a label saying the period for which it can be stored, it's transported between facilities perhaps, if there's remote compounding. That's very, very different indeed from simply taking a vial and using it to inject straight into somebody's eyes. And mode 2, insofar as it therefore meaningfully differs from mode 1, is all about the application of that process of manufacture within the relevant NHS hospital trust. And I'm going to show you the guidance that makes it clear that there is a world of difference between taking out a single injectable amount and the process of aliquoting. So one of the key things that goes with that is any time you're looking at storage or shelf lives or issues like that, you're looking at a manufactured product. You're looking at an intermediary product. So modes 3 and 4 plainly entail manufacture, and so does any mode 2 operation entailing multiple aliquoting. The fourth theme is that whatever is meant by the key term modification coined by the CJ in Apposite, it must embrace, we say, anything that risks affecting the manufacturing quality. And that's because of the indissociability of the concerns on quality and the controls over manufacturing. And it's also because of the very structure of the reasoning of the CJEU. One of the things that the judge below criticised was, as she described it, I think, the illogicality of having a prior prescription requirement. She said it was an illogical thing to have, and that was one of the reasons why she concluded that there was no necessity in every case for a prior prescription. There is, in our submission, nothing at all illogical about a prior prescription requirement if what you're doing is saying all of the clinical risks in question are already sufficiently controlled by the fact that this is a patient under the control of a doctor who has decided that this is the product to be administered. But if you go back to the 3 bullet points, if you have them in front of you, and ask yourself which of the risks is controlled or catered for by that clinical supervision, it is only the risks that are otherwise catered for by labelling, by packaging, by concerns about use. The fact that a doctor has made a prescription doesn't in any way cater for the manufacturing risks if the product in question is of a deficient quality. And that's why we say the scheme is indeed logical and leads one to the conclusion that anything affecting quality is a modification. The 5th theme, a very short one, is that placing on the market and supply are very wide terms indeed, both under the directive and yet more clearly under the domestic implementing legislation. And they plainly embrace, and necessarily must embrace, any form of supply to an end patient or to an intermediary. So they embrace wholesale supply and retail supply, whether or not for the payment of money. There's nothing in the directive and nothing in the HMR that makes the movement of consideration a relevant question or consideration as to whether or not there has been a supply. And the last theme is this. Wherever you go in the analysis with the EU law provisions, you always end up back at section 10 of the Medicines Act. You end up there, if we're right, and there is a modification, and therefore compounding is occurring under Article 3, because Article 3 requires a pharmacist operating pursuant to a prior prescription. But if we're wrong about Apposite, you still end up there, because Article 42 bis, the exception for national rules permitting pharmacists to package for retail supply, also takes you back to section 10 of the Medicines Act. And that domestic gateway is very different to the gateway in Germany. It's a pharmacist-only gateway, it's a prescription-only gateway, and it's a gateway which all of the MHRA's guidance suggests is only intended to contemplate small-scale production, what is called in the language of section 10, preparation, in contradistinction to manufacture. And that's one of the reasons why the guidance is relevant. So I hope those themes will help to explain why I take you to what I'm going to take you to. And can I then dive straight into the directive, which is in Authorities Bundle A. At tab 3. I know my Lord Justice Underhill has been poring over the recitals because you asked us to provide them. Apologies for the gremlin that led to them not being produced initially. Something to watch out for. Consolidated versions don't always print out the original recitals, even though they show on the screen. Recital 2. This is the foundation of just about every single pharma case. The essential aim of the rules governing the production, distribution and use of medicinal products must be to safeguard public health. That is the touchstone that everything comes back to, and why the touchstone for the analysis of appetite has to be that question of risk to public health. Has to be attained, recital 3, by means that won't endanger free movement. And then I think we can move on to recitals 26 to 29. In order to facilitate free movement, minimum requirements should be laid down. And 28, you can see, before an authorization to market an immunological product, etc., the manufacturer must be able to demonstrate his ability to attain batch-to-batch consistency.
Sorry, which was the recital you were reading before 28?
26.
Thank you. Yep.
33 is a recital I think Mr. Locke would like you to see.
Which one, sorry?
33, it echoes Article 4.3. Provisions dealing with the classification of medicinal products for purposes of supply do not infringe national security, social security systems. And then 35, which is the recital that's figured most prominently in Apposite and IEFA. It's necessary to exercise control over the entire chain of distribution of medicinal products, from their manufacture or import into the community through to the supply to the public, so as to guarantee that such products are stored, transported and handled in suitable conditions. The requirements which must be adopted for this purpose will considerably facilitate the withdrawal of defective products from the market and allow more effective efforts against counterfeit products. That recital has to be read with the next recital, 36, because it's those two recitals that justify the introduction of controls over wholesale dealing, which was not an original concern of the directive. It was added into the scheme of the directive by subsequent, the scheme of the original directive 65/65 by subsequent amendment. Well, those provisions in question, they're all about the need to ensure control throughout the wholesale distribution system. And that's why the wholesale dealer's license was introduced. And of course, one of the problems with some of the exemptions under the directive is that they take you not just out of the marketing and manufacturing authorization regime, but also outside the wholesale dealing regime in question. They exempt on their face potentially the application of those. But we'll see that's not actually how the directive deals with the problem. Then recitals 53 to 54, each undertaking which manufactures or imports should set up a mechanism to ensure that all information supplied about a medicinal product conforms with the approved conditions of use. So there's an obligation throughout distribution to tell the people to use it in the correct way. 54, in order to ensure continued safety, there needs to be a pharmacovigilance system. And that means you need to be able to report back all of the uses of the medicine in the relevant health service or the private system in order to alert safety concerns. And then lastly in recitals, that's fleshed out at 57 to 58, the ongoing pharmacovigilance obligations of marketing authorization holders. And insofar as Avastin is being treated, even when compounded, as the same licensed product, that thrusts on its face the pharmacovigilance obligations that the directive creates upon Roche, even though Roche has had no part at all in the manufacture of this product or its intended use. And indeed, even though Roche has gone so far as to have had something explicitly put into the SMPC saying it's not authorised for use in intravitreal injections. Article 1 contains some definitions. Article 1.2 is the definition of medicinal products, the well-known presentational and functional alternative definitions.
Sorry,
a medicine could be a medicine by its presentation. You can claim something is a medicine, that's enough to make it a medicine, and that brings quackery, etc., within the scope of the directive, or it could be a medicine by its function, which is 1.2b.
It's a substance presented for treating. That brings in the way in which it is recommended for use.
Absolutely, and that's why the
indication which it's said to treat.
yes. Then you have a definition of substance, you have a definition of active substance, and then turning on a little bit, 117, page 24, there's a definition of wholesale distribution of medicinal products. All activities consisting of procuring, holding, supplying or exporting medicinal products apart from supplying medicinal products to the public. They're all wholesale distribution of medicinal products. There's no exemption for those activities if they're done pursuant to a prescription. So whether or not there's a prescription accompanying the transaction in question is not relevant to whether or not it amounts to wholesale dealing. And then over the page at 25, you have the definition of the strength of a medicinal product.
Agenda. Oh, is it which recital? Oh, sorry, which?
22.
22. Yep.
And that definition of strength is by reference to the dosage form, i.e. as used. And that's why the dosage of Avastin is by reference to the patient weight and by reference to the medicine as diluted, as it's intended to be, because Avastin for treatment of cancer is intended to be diluted and then administered at a certain amount per kilogram weight of the patient. And then you have the definitions of immediate and outer packaging, and these are very relevant to the Annex 1 obligations in the directive. And very simply, as a general rule of thumb, things about the immediate packaging are that much more sensitive, are that much more important from the perspective of quality. Because if you're dealing with a complex active substance like a biological medicine, and it may interact with the immediate packaging, the choice of the immediate packaging is obviously central to the safety of the product, as well as its shelf life, stability, etc. Outer packaging is more concerned with the presentational labelling issues. Then you have labelling defined as well. The package leaflet, that's the simplified version of the SMPC that you probably recall from every single box of medicines you open up, try to get to the blister pack and there's that leaflet wrapped around it. That's the packaging leaflet. And then the term variation or variation for terms of marketing authorisation is defined at 26A, and that takes you to separate provisions, the operation of which I don't think is disputed. So those are the definitions. Then we come to the key provisions. The first key provision, Article 2. There are 3 limbs to this. This directive shall apply to 1, limb 1, a medicinal product for human use. So that takes you back to the definition at 1.2. No dispute about that in this case. Intended to be placed on the market in the member state. That's the term that we're going to be looking at. Placed on the market. And either prepared industrial or manufactured by an industrial process. That was ground 3C, which has now disappeared. So 3 limbs to get within Article 2. You then have Article 3, the compounding exception. This directive shall not apply to 1. Any medicinal product, no doubt about that now, prepared in a pharmacy, so that's locational, in accordance with a medicinal prescription for an individual patient, commonly known as the magistral formula. And note that like the domestic regulations, there's a contrast between the words manufactured, etc., and prepared. In all of these retail operations, the language is not of manufacture, it's of preparation. That's the compounding exception that everyone thought was potentially in play until IEFA.
It's probably not relevant, but you may just be gratifying my curiosity. Where does the term the magistral formula come from, and what does it mean?
No idea, and it means what Article 3.1 says it means.
Well, yes and no. I mean, that's an obvious answer, but I wondered whether it is in fact a concept known, as it were, deriving from medical history.
It is. I think it's a concept well known to pharmacists. Yeah, it's a pharmacological term of art. And it's contrasted to the officinal formula in 1.2, which is where you make up a medicine to effectively, to put it in common parlance, a well-known recipe. So there is a British pharmacopoeia, there is a European pharmacopoeia that contains recipes for well-known products.
Going back to sort of what pharmacists used to do.
Absolutely,
to
absolutely.
Mix up coloured powders in different brown glass bottles.
Yes.
Put them into make-up tablets.
And there are all kinds of practical reasons why there are actually certain categories of medicine where you will operate in that way. Dermatological treatments, I think, is one of them, where you mix up the particular dermatological formula according to one of a variety of recipes, depending upon the eczema or the skin condition the person in question is presenting. Now, these are all reactive operations, preparation in response to a medical prescription, in the case of one, and in the case of two, it's a medicinal product which is prepared in a pharmacy in accordance with the prescriptions of a pharmacopoeia. So as opposed to it's a pre-existing recipe from the pharmacopoeia and is intended to be supplied, and this is important, directly to the patient served by the pharmacy in question. What this provision tells you, beyond argument, is that something that is made up in-house and supplied retail direct to the patient is but for the exemption within scope of the directive. And that's an immediate answer, as you'll see, to much of the argument that's been put forward about mode 2 not involving a relevant supply. The relevant supply is by the person making it up in-house to the patient. And Article 3.2 tells you in unanswerable terms that that type of retail supply of something that you have made yourself is a supply within the scope of the directive.
Suggesting quite a rigorous drafting technique. It's not unknown in legislation, including Euro legislation, for things to be included for the avoidance of doubt. It doesn't necessarily. It just says this directive shall not apply to, not.
My Lord is accusing me of a black letter English law approach. What I would say is it's also entirely consistent with any proper public policy approach to the construction of this directive, because the idea that the directive would allow you to make up your own medicine and sell it retail to a customer cuts across any number of other provisions in the directive, not least and not most obviously the presentational limb of a medicine, because as I indicated, that's intended to catch quackery, home cures and things like that, where the magic oil will cure all your back ailments. I might make that in the back of my garage and sell it. It would still be a medicinal product, even if I sold it direct to the patient physically, or even if I sold it over the internet to the patient. It would still
be a medicinal product. I was thinking more about the placing on the market.
Well, it would still be a placing on the market that would be captured, because I'd have made it in my garage and I'd have sold it to Mr. Perrette when he comes round to my house to answer my advertisement for the sale of my snake oil. If I sold it to him retail, it would be a placing on the market of a presentational medicine for the purposes of the operation of the directive.
Well, let's not have the debate now. We're not talking about that situation. We're talking about what happens inside a hospital when the hospital pharmacy supplies something. I don't think you can say that Article 3 shows that that would be a supply or a placing on the market, because otherwise it wouldn't need to be said.
My point is this, my lord, the relevant focus is not the supply by the pharmacy division to the doctor. The relevant supply is the supply of the medicine by the hospital.
Well, that's a separate point. That's a separate point.
But
let's leave this. Let's leave this.
Yes,
for
very good. So that's Article 3. Article 4.3 is again something Mr. Locke would like you to see. The provision that the provisions of this directive shall not affect the powers of the member state authorities either as regards the setting of prices for medicinal products or their inclusion in the scope of the National Health Insurance Scheme. And we say nothing in this case is on that subject at all. It's about whether or not the medicines in question are licensed or unlicensed. Article 5, this is the specials formula. Again, like the structure of Article 3, it's an exemption that's optional for member states and requires implementation in consequence. a member state may, in accordance with the legislation in force and to fulfil special needs, that's the relevant criterion, exclude from the provisions of this directive medicinal products, and then here's what they have to be: supplied in response to a bona fide unsolicited order, formulated in accordance with the specifications of an authorised healthcare professional, and for use by an individual patient under his direct personal responsibility. It has a very different structure to Article 3. There's no requirement for a prior prescription, rather a prior specification. It has to be in response to special needs, which, as we'll see, means there is no other licensed medicine available to treat the patient. It needs to be a bespoke or tailored medicine to meet the needs of a particular patient who can't be serviced by medicines otherwise lawfully on the market. We'll see the case law that shows that in order to do this, you can actually do it in advance, and you can make it in bulk in advance, by contradistinction to Article 3 of the directive. Then Article 6, no medicinal product may be placed on the market of a member state. So you see the echo back to Article 2. It's here placed as opposed to intended to be placed, unless a marketing authorisation has been issued by the competent authorities of that member state in accordance with this directive, or unless an authorisation has been granted under the centralised regulation. So there is only one initial placing on the market, unless and until that particular medicinal product is changed. And what this case is about, and this is the only point at the review of this directive I'm actually going to stop and look at a case. What this case is really about is the fact that the sorts of changes that are needed to trigger the creation of a new medicinal product are in some instances really quite trivial. And that's well illustrated by the parallel importation case of Aventis, which is in Authorities Bundle B, tab 17, page 483. Now, a little bit of background to this case. You have Aventis.
Sorry, could you just give us that?
It's Bundle B, tab 17, page 483, maybe. You have Aventis Pharma Deutschland, which is the originator, the manufacturer, the holder of the marketing authorisations. And you have a repackaging operation, Coal Pharma GmbH. And the position was as follows, and you can see that this from the facts in the case, in particular from paragraph 9 onwards. Aventis held two centrally granted marketing authorisations, so granted by the European Commission on the advice of the European Medicines Agency under the centralised regulation. One European marketing authorisation was for 10 cartridges, and a second was for 5 cartridges. And what had happened is that it released the products in one market, I think it was France, with French leaflets and French labels, in the 5-pack, and they had launched in Germany a 10-pack with German leaflets and labels, etc. And the question between them was what was effectively necessary in terms of repackaging of the relevant medicinal products. And Aventis was saying it would be consistent with the two marketing authorisations, and in particular the one for 10 cartridges, if Coal Pharma simply took the two 5 packages and take them together and put a new label on that. And therefore there was no excuse for taking them out of the boxes, making a new box and applying new stickers with potential trademarks violations in relation thereto. And they were effectively therefore saying there was no necessity under the EU trademark exhaustion doctrine to engage in more substantial repackaging of the kind that Coal Pharma had in fact engaged in. Coal Pharma was saying, no. If you splice these 2 packs together, that is not the packaging that was approved in the marketing authorisation. And therefore we would be placing an unlicensed product on the market and we'd be committing criminal offences, etc. We're entitled to repack so that it conforms with the 10-pack marketing authorisation. That was their argument. The Commission agreed with Coal Pharma, and so did the court. And in particular, the court concluded in its findings, which starts at 21 and following, that, and the key passage is at 25, that it must be concluded, as the Norwegian government and the Commission have urged, that the detailed and specific requirements regarding the packaging of the medicinal products, which are the subject of the Central Marketing Authorization, which are intended to prevent consumers from being misled and thereby to protect public health, preclude the bundling of the packages of those medicinal products. So that sets the bar very low indeed for what constitutes an unlicensed medicinal product. And it's that bar, set in that way, that the case law in Aventis and IEFA is, in my submission, effectively a response to. And I'll show you why.
Have the judgment of the opinion of the Advocate General.
In that case,
Yeah.
no, but we can supply it overnight.
I wouldn't mind seeing it. Yes,
Of
thank
course.
you.
So, very important, it sets the bar very low, but also note another point. What was at issue here, as it is in all parallel importation cases, is repackaging not into an unlicensed medicinal product, but so as to conform with an extant marketing authorization. That's what happens with all parallel importation. The basis for parallel importation is that there is already in the state of import a product with a marketing authorization which you repack to conform with. And that's why, for a parallel import, you can get a manufacturing license, because it's lawful to manufacture something that has a marketing authorization. Okay. The last thing to note about Article 6 is the second paragraph. This is, in the jargon of pharma lawyers, the global marketing authorization. And what this does is codify existing CJEU case law to this effect. If, after you've originally got a marketing authorization for, let's say, indication 1, cancer treatment, ovarian cancer, and you later apply for a variation not only to treat ovarian cancer, but also brain cancer, pancreatic cancer, or something of that kind, that is a different indication, and that is a variation, but nevertheless, it is treated as being part of the same global marketing authorization. Now, the significance of that is what happens to data packages and what the incentives are to do the clinical research required to stimulate the exploration of different indications. And I'll explain why that's relevant in due course. There is then a variation regulation, which you have, and it's probably just sensible to break very briefly to have a look at it, in tab 1 of the bundle. No, it's not tab 1.
No, that's the dreaded SPC.
Yeah, no, it's at page 289. My numbering is let me down. I think it's at tab 7. Yeah, the 1 looks like a 7. I'm sorry. This is the variation regulation. I don't think that there's any dispute between us. This sets out a series of different processes that you have to go through depending on the seriousness of the variation. And the MHRA is very clearly of the view, we're very clearly of the view, it's really, I think, undisputed, that such is the extent of the changes to Avastin into CB that were Roche to apply for it, it would be the very most serious of variations that the variation regulation caters for. It would, in effect, require them to resubmit an entirely new, full-blown application for approval. That means the full clinical package. It means the full Annex 1 package. This is not some trivial variation, like the variation in the location of the supplier of your packaging materials or something of that kind. This is external packaging materials. This is going to the very heart of the safety, quality and efficacy of the product, both in design and in quality, and therefore it would require a full-blown variation. And if you want, for your notes, a reference to the MHRA saying as much, it's in Supplementary Bundle B, tab 22, at page 356 to 358. And in the guidance the MHRA has put out at Supplementary Bundle B, tab 23, page 460. So this is a major variation within the scheme of EU pharma law. Back to the directive. The next thing we need to look at is Article 8. And here I'm sure you're going to accuse me of complicating matters. Because what Article 8 does in 8.3 is explain all of the documents that you have to submit in order to get a marketing authorisation. All of the documents in Annex 1, submitted in accordance with Annex 1, that address the topics in A through to N. And these topics, by reference to those 3 bullet points, break out into 3 different subjects. They break out into topics that are related to the manufacturing quality of the thing being made. They break out into the documents relating to whether it's safe by design in its safety and efficacy, and they break out into things that are relevant to packaging and presentation and use. And it's probably easiest to start with the materials relating to safety by design. This is 8.3i. Results of pharmaceutical, physico-chemical, biological or microbiological tests, preclinical trials, clinical trials. This is the infamous data package. And this is what almost all pharma litigation in this court and very often elsewhere is about. It's about the huge investment and time and money to do the clinical and preclinical trials to show that a particular product or indication is safe. And the centrality of that is it feeds through into Article 10, page 34, and the well-known rules derogating from the requirement to provide your own data package when the data package of the reference product has expired, the 8+2 rule and the rule in Article 10.5 that you may get an extra year of protection for an additional indication if you've submitted additional data for that purpose. So that's the core clinical material, and that's the subject as to whether or not the product in question, properly made, is safe and efficacious in use. Pretty much the rest of the topics in 8.3a onwards are about manufacturing or product safety, product labelling. So if we go through them, you've got the name of the corporate in question, and its permanent address, and where applicable of the manufacturer. So if they're not vertically integrated, you have to name the separate manufacturer. You have to name the medicinal product, qualitative and quantitative particulars. Then D, description of the manufacturing method. E, therapeutic indications, contraindications, adverse reactions. F, this is important, posology, pharmaceutical form, method and route of administration, so that's intravenous drip versus intravitreal injection, and expected shelf life. Over the page, G, reasons for any precautionary safety measures to be taken for the storage of the medicinal product, its administration to patients, and for the disposal of waste products. That's a blend of manufacturing and packaging. Then H, description of the control methods employed by the manufacturer, that's all manufacturing. A written confirmation that the manufacturer of the medicinal product has verified compliance of the manufacturer of the active substance with the principles and guidelines of good manufacturing practice by conducting audits in accordance with point F of 46, that's called GMP in the slang. Then skipping over I that we've covered, you've got the pharmacovigilance system, and then J, a summary in accordance with Article 11 of the product characteristics, a mock-up of the outer package, the packaging, containing the details provided for in Article 54 and the immediate packaging, so this is packaging concerns. Documents showing that the manufacturer is authorised in his own country to produce medicinal products. This is the beginnings of the stitching together of MFAs and MAs, and copies of authorisations, etc., over the page. So let's then just look at what the directive says vis-à-vis manufacturing in this particular context. Skip on to Article 40, Title 4, Manufacture and Importation.
Page is Article 40.
Page 60, my lord. Member States will take all appropriate measures to ensure that the manufacture of the medicinal products within their territory is subject to the holding of an authorisation. This MFA shall be required notwithstanding that the medicinal products authorised are intended for export. Authorisation referred to shall be required for both total and partial manufacture and for the various processes of dividing up, packaging or presentation. And then there's this critical provision that's featured heavily in Apposite and IEFA. However, such authorisation shall not be required for preparation, again the same language as Article 3.1, dividing up, changes in packaging or presentation where these processes are carried out, and then these words, solely for retail supply, and all the case law makes it plain that that proviso, solely for retail supply, applies to all that follows, not just pharmacists, by pharmacists in dispensing pharmacies, or by persons legally authorised in the member states to carry out such processes. So that, along with Article 3, is one of the two gateways that takes you to Section 10 of the Medicines Act. You're taken to Section 10 if there's compounding, and you're taken to Section 10 if there's any form of preparation, dividing up, etc., because that is a subset of manufacture. Then over the page, 41A, in order to obtain the manufacturing authorisation, the applicant should meet at least the following conditions. A, specify the medicinal products and pharmaceutical forms which are to be manufactured or imported, and also the place where they're to be manufactured and controlled. And so what you immediately have, where there's a separate manufacturer, is a correspondence between the marketing authorisations, which name the manufacturers, and the manufacturing authorisations, which name the particular products the manufacturer is authorised to manufacture.
So, sorry, which provision was that?
41A.
41A, thank you.
You have to specify in the MFA application what it is that you're going, which MA product it is that you're going to be manufacturing. Now, if we look just very briefly at the rest of these provisions, there are all kinds of requirements, mainly centred around the concept of a qualifying person who supervises manufacture. 46 sets out some of those requirements at 62. A holder of a manufacturing authorisation shall at least be obliged to dispose of the authorised medicinal products only in accordance with the legislation of the member states concerned. So once you're manufacturing, you have to comply with rules about onward sale, etc. And F, you can see, compliance with the principles of GMP. Then there's pretty exhaustive regulation in the provisions about who a qualifying person is.
Sorry, so disposal means supply, does it?
Yes, it does, yeah. And then 47, the Commission is empowered to adopt delegated acts to explain what GMP is, and I'll show you the GMP provision very briefly. And then 48 and following deals with the qualified person. And in particular, you can see it's very prescriptive in Article 49 as to the qualifications of the person who is supervising the manufacturing process. They have to be extremely experienced, they have to have undertaken courses, they have to show they've acquired practical experience. This is 48.3 of at least 2 years in one or more undertakings. They've effectively had to have done an apprenticeship. So those are the...
Did you say 48.3?
48.3. A qualified person shall have acquired practical experience of at least 2
I
years.
think that's 40.
49. I'm so sorry. Page 66, near the bottom. Now, the Good Manufacturing Practice Directive is in same authorities bundle at tab 4. The only bit you need to look at in my submission is Article 5, compliance with marketing authorisation. The manufacturer shall ensure that all manufacturing operations for medicinal products subject to a marketing authorisation, and you remember that ties back to 46A, are carried out in accordance with the information provided in the application for the marketing authorisation as accepted by the competent authorities. So GMP is you comply with what the marketing authorisation tells you is the way that the product is going to be manufactured. And the reason why it refers to subject to a marketing authorisation is in contradistinction to the other thing to which this article applies, which is the making of an investigational medicine for which there is no marketing authorisation but an exemption scheme under the directive. It's not a provision that's in any way permissive of manufacturing unlicensed medicines. And this is a point with respect that's been somewhat lost in all of this. There is no prospect of any manufacturing licence being obtained to make CB unless and until there is a marketing authorisation for CB. There is simply no way that you can obtain a full-blown manufacturing licence for CB. All that you can do is manufacture it pursuant to a domestic specials licence where the conditions for that are made out, as they will be for ophthalmological conditions other than wet AMD, but they will not, save perhaps in the rarest of cases of a patient who's allergic to the excipients in both Eylea and Lucentis, they will not be able to do a special for those products. So there's no prospect of even a national manufacturing authorisation, and therefore the only way that manufacture of CB will even putatively be possible is if you can get it through the Article 42 bis gateway, which takes you back to Section 10 of the Medicines Act. Now,
So which is the Article 42 bis gateway?
if you go back to the directive and look at Article 42 bis, it's the provision that says that the requirement to have a manufacturing, page 60, the requirement to have an MFA shall not be required.
Sorry,
Preparation.
wait, you're going too fast for me. Page 60 doesn't have Article 40.
40. 40.
Oh, right, I'm with you now. So I thought you said Article 42. That's what confused me.
42 bis.
Okay, no, I've got it now. Thanks. Yeah.
So it's impossible to hold any form of directive compliant manufacturing licence to make CB for wet AMD unless and until there is a marketing authorisation to that effect.
Looking at 40 sub 2, whatever comes before this, first subparagraph.
Yep.
I think you read this as saying that dividing up packaging or presentation is a subset of manufacture. Is that the natural reading of that? If you read for both total and partial manufacture
And,
for the various processes of dividing up
yes, it's
packaging or presentation.
distinguishing between manufacture and dividing up packaging and presentation.
Yes, it's not making. It's not saying that those things are manufactured.
Those things are manufacture.
You're saying that, but I don't read that.
Well,
Well, they require a manufacturing licence,
absolutely. I think,
manufacturing authorisation.
if you like, the global term manufacture or the global operations of manufacturing embrace the hardcore assembly line manufacture process itself.
You get that from somewhere else.
You get that from all of the details in the directive about manufacturing practice, and indeed you get it from the MHRA's standard template for a manufacturing licence,
Right, so
which allows you to specify that all you want to do is repackaging.
So I think what you're saying is that although the first paragraph of 2 may well envisage that dividing up packaging or presentation are something separate from total or partial manufacturer, you need an authorisation for all those things, and that authorisation is referred to as a manufacturing authorisation.
Yes, that's right. Yes, and it could be that you have one ingredient of the medicine made separately, effectively the active made separately, that requires a marketing authorisation, and then to combine it with the excipient and put it in the immediate packaging, that's another manufacturing authorisation. All of the processes need to be covered by a manufacturing association. So you may have a medicinal product that involves 3 or 4 manufacturers in its eventual supply. I've shown you the provisions on packaging. They then take you to separate provisions of the directive, starting with the SMPC, which is
back in the good manufacturing practice
no,
directive.
we're back in the main directive, my lady. I'm sorry. I'm trying to.
Where are we in that directive?
Page 36 of this same bundle. SMPC is the information provided to healthcare professionals, and you'll see all the various topics broken out there. And in particular, under 6, you'll see pharmaceutical particulars, page 37, and they include shelf life, special precautions for storage, nature and contents of container, special precautions for disposal. And then the last thing I need to show you, I think from the perspective of the workings of this directive, I'm not going to take you through the details of the pharmacovigilance system, simply because time doesn't allow, but it does what you expect it to do, which is require an unbroken chain of information down to the end patient, so that if there are any adverse effects, they're reported and acted upon. Annex 1 of the directive specifies all of the Article 8.3 material.
Where do we find Annex 1?
It starts, my lord, at page 132.
Thank you. Yeah, you say, sorry.
And substantial parts of this are concerned with the topics of quality. So I think we can start at page 145. After the
Remind me, I'm sorry if you said it already, but we've been going at rather apace. To what, where in the text is Annex 1 referred to?
in Article 8.3, amongst, I think, many other places. But that's the principal gateway to getting here, because it tells you where to find the further detail of the materials that you're going to have to satisfy under Article 8.3.
Thank you.
So you have to submit all the documents in the categories in accordance with Annex 1.
Got it.
And if you look at 145, you'll see there's detail on the manufacturing process of the active substance. Description of the active substance manufacturing process represents the applicant's commitment for the manufacturing.
Again, sorry, you're going too fast. Where are we going now?
Bottom of page 145, 3.2.1.2.
Yep, got it.
Over the page, all materials needed to manufacture. And then C, for biological medicinal products, the following additional requirements shall apply. And this reflects the fact that biological medicines are particularly complex and particularly riddled with problems about efficacy, stability, etc., that they are separately regulated in terms of marketing authorisations by the Commission, but they also have separate Annex 1 particulars in relation to them. So there's a whole set of details here about biological medicines, of which all three products we're discussing are forms. And you note at the end of that section C, the manufacturing facilities and equipment shall be described. Over the page at 147, you have to specify at 3.2.1.6 container and closure systems of the active substance. And at 3.2.1.7, stability of the active substance. You have to submit stability studies to show that the product is stable. Over at 149, you have to describe at 3.2.2.3, right at the foot of 149, the manufacturing process of the finished medicinal product. You have to describe it, and over the page in the indents, you can see, first instance, it shall include at least mentions of the various stages of manufacture, including process controls, corresponding acceptance criteria, so that an assessment can be made of whether the processes employed in producing the pharmaceutical form might have produced an adverse change in the constituents. So that's why manufacture goes to quality, amongst many other reasons. And then lastly, I think in this Annex 1 review at page 152, right at the top, 3.2.2.7, container and closure of the finished medicine, a description of the container and closure systems, including the identity of each immediate packaging material. That means the glass vial or the plastic syringe for a pre-filled syringe, and their specifications. What plastic are they made of? What glass are they made of? The specifications shall include description and identification. Non-pharmacopoeial methods with validation should be included where appropriate. And then see the contrast. For non-functional outer packaging, only a brief description shall be provided. For functional outer packaging materials, additional information shall be provided. Now, what functional packaging is something like light protective wrappers, something that's needed in terms of the external wrapper to continue to assure the quality of the product. And then you have to provide details of the stability of the finished medicinal product at 3.2.28, immediately below. So those are the manufacturing provisions. One last set of things I need to show you in this directive, which are the relevant provisions relating to wholesale. They're in Title 7, page 82. And these apply to the things that have been manufactured in accordance with the marketing authorisation.
Sorry, just so I can understand the structure of the directive.
Yes,
Title 2 was scope, Title 3 was marketing, Title 4 was manufacture. What are 5 and 6?
5, I think, is leafleting, which I didn't take you through.
No, I didn't ask you to take it through. I just want to get a feel for what's covered.
Title 5 is labelling and package details.
Yeah, thank you.
Title 6, I can't for the life of me remember.
I was only doing this to
Classification.
tease you, Mr. Dunham.
Well, very effectively, my lord.
Classification. Yes,
Classification.
okay, thank you.
And then Title 7 is wholesale distribution and brokering. Article 76. Without prejudice to Article 6, that's the requirement to have a marketing authorisation, Member States shall take all appropriate action to ensure that only medicinal products in respect of which a marketing authorisation has been granted in accordance with community law are distributed on their territory. So you can only distribute a product that has a marketing authorisation. 2. In the case of wholesale distribution and storage, medicinal products shall be covered by a marketing authorisation granted pursuant to Regulation 726/2004 or by the competent authorities of a member state in accordance with this directive. So doubling down on 76.1. And then 77.1 says, Member States shall take all appropriate measures to ensure that the wholesale distribution of medicinal products is subject to possession of an authorisation, the wholesale dealer's licence, to engage in activity as a wholesaler in medicinal products, stating the premises located on their territory for which it's valid. And then 77.3 provides, possession of a manufacturing authorisation shall include authorisation to distribute by wholesale the medicinal products covered by the authorisation, but then you have to read on, possession of an authorisation to engage in activity of a wholesaler in medicinal products shall not give dispensation from the obligation to possess a manufacturing authorisation and to comply with the conditions set out in that respect, even where the manufacturing or import business is secondary. And then over the page at 84,
Sorry, it's just been niggling at me. In 76.1,
yes,
the requirement applies to distribution.
yes,
76.2 treats wholesale distribution as a subset of distribution. 76.1 says...
yes, that's right, that's right. So,
So what is non-wholesale distribution?
It's retail distribution.
So retail sale?
Retail sale. So where, for instance, you've got a general sales medicine, you have to ensure that the general sales medicine is still in its original packaging, etc., still the product that has a marketing authorisation before it's sold in a supermarket. So it's effectively saying that the member state must ensure that all forms of distribution of medicinal products are distribution in accordance with the marketing authorisation. And then in particular, in 76.2,
Yeah, that's
wholesale
fine. Thank you.
distribution
You've
requires a
answered my question.
Yeah. Over the page at 80, holders of a wholesale distribution licence must fulfil the following minimum requirements. And then if you look at C, they must supply medicinal products only to persons who are themselves in possession of a wholesale distribution licence or who are authorised or entitled to supply medicinal products to the public in the member state concerned. So that means General sale medicines can be supplied to corner shops and supermarkets. Restricted sale medicines, pharmacy-only medicines have to be supplied to pharmacies, and prescription-only medicines have to be supplied in accordance with prescription-only controls. And that is a matter for national law. And that goes back to my point I made at the beginning, that once you get to the retail supply, the logistics of retail supply are not fully harmonised by the directive. And then Article 82, for all supplies of medicinal products to a person authorised or entitled to supply medicinal products to the public, the authorised wholesaler must enclose a document that makes it possible to ascertain the date, the name and pharmaceutical form of the medicinal product, the quantity supplied, name and address, and batch number. And the batch number is all part and parcel of ensuring a working system of pharmacovigilance and enabling batch recall to occur if there is a safety problem with the medicine. And then you see, after batch recall, member states shall take all appropriate measures to ensure that persons authorised or entitled to supply medicines to the public are able to provide information that makes it possible to trace the distribution path of every medicinal product. So part of the reason for regulating wholesale distribution is in order to ensure that you have that full chain of custody, which takes you back to recital 35. Do you remember the one I referred to at the beginning? So, that's the directive. What then of the regulation, the centralised regulation? We can take this extremely quickly. It's in Authorities Bundle 1, tab 5. Purpose in Article 1 is to set up procedures for the authorisation, supervision and pharmacovigilance of medicinal products and to establish the EMA.
So sorry, where are we? To tab 5, did you say?
Bundle 1, tab 5. So, if my Lord remembers...
Sorry, my bundle, what do you mean, authorities bundle?
Yes.
Minor called A, but it's the same one.
It's the same one, yeah.
I must have just misled myself. What did you say the title was called again?
It's called Regulation 726/2004.
Yeah, so sorry.
No problem. Page 195. Now, the purpose of this regulation is to effectively carve out certain medicines types listed in Annex 1 and to give the European Medicines Agency the monopoly on the grant or not of a European-wide marketing authorisation. And it's probably sensible just to go straight to Annex 1 so that you can see what's in it. Annex 1 is at page 260, and the first thing that appears in it is medicinal products developed by means of one of the following biotechnological processes: recombinant DNA, controlled expressions of genes, hybridoma, and monoclonal antibody methods. And all three products at issue here, all the anti-VEGFs, are monoclonal antibody methods. So the Commission, through the EMA, has a monopoly over authorisation, but they apply the same criteria in Article 8.3 and Annex 1. It's just a different procedure to arrive at assessment of these particular medicines against the same common assessment standards. And in effect, the way that the regulation works is only to look at the Article 8.3i material and that so far as it touches on questions of quality. Manufacturing licences are still, even in relation to these medicines, governed by national law. So there's the same correspondence between the marketing authorisation and the manufacturing authorisation, but there's no European manufacturing authorisation that goes with this. So,
When you say governed by national law, you mean governed by the directive?
Governed by the directive and thus the national law of wherever the manufacturer is located. Now, this regulation...
I don't understand. Governed by it, or you mean it's issued by the MHRA?
Well, if your manufacturing operation is in the UK
Yes.
for making a monoclonal antibody product, your manufacturing authorisation will be in the UK. The marketing authorisation will be granted by the EMA.
Right, but the manufacturing
Or commission.
authorisation still has to...
You still have to have a manufacturing authorisation.
No, but it still has to follow the directive.
Absolutely.
Yeah,
Yes.
it's not just domestic law.
No. Absolutely, my lady.
I think your use of the word governed by was misleading.
When I say governed by domestic law, I mean the domestic implementation of the directive. And that's probably the source of the confusion. So you would be applying under the human medicines regulation for a manufacturing authorisation which would conform with the requirements of the directive, because that's how the directive is implemented. So this contains its own equivalent to Article 6 of the directive in Article 3. No medicinal product appearing in the annex may be placed on the market within the Union unless a marketing authorisation has been granted by the Union in accordance with the provisions of this regulation. And then Article 4, page 196, applications for the marketing authorisations referred to shall be submitted to the agency. And then the common standards are used, you can see from 197, Article 6, each application for the authorisation of a medicinal product for human use shall specify and completely include the particulars of the documents referred to in Article 8.3, 10, 10a, etc. of the directive. So the same standards being applied for different class of medicines. And you can see 8, the point I was trying very inelegantly to make. The member states, 8.1, shall forward the information showing the manufacturer of a medicinal product or the importer from a third country is able to manufacture the medicinal product concerned and carried out all necessary controls in accordance with the particulars and documents supplied to Article 6, and where it considers it necessary to complete its examination of an application, the committee may require the applicant to undergo a specific inspection of the manufacturing site of the medicinal product concerned. So that's the regulation. Can we now turn to domestic law? And that is contained in the next bundle. Bundle B. And let's start with the human medicines regulations at tab 13, bundle B. Probably the first place to start is Regulation 315, page 389. For the purposes of this regulation and Regulation 4, special provisions for pharmacies, etc., a medicinal product is authorised if there is in
You're going
force...
too fast for me.
I'm so sorry, man.
Found it, yep. So this is Regulation 4.
315, just above Regulation 4. For the purpose...
Thank you, got it.
is authorised if there is in force a marketing authorisation. You can ignore the rest of B to do with the material. And then 4 is the regulation that gives effect to the exemptions in Section 10 of the Medicines Act for pharmacies. It's headed Special Provisions for Pharmacies. And this is very important to note. It exempts only the requirement to hold a manufacturing licence, Regulation 17, or a marketing authorisation, Regulation 46. It does not exempt any requirement to hold a wholesale dealer's licence. And there is MHRA guidance about when pharmacists must hold wholesale dealers.
Sorry, where's the exemption in relation to...
There is no exemption.
46, sorry.
So 4.1...
17 and 40 are both in 4.1. Yep, got it.
Yeah.
Thank you.
There's
I have
nothing
the point.
exempting the wholesale dealers provisions in anything that follows here. Chapter 2, so they say those MFA and MA requirements do not apply where any provision of Section 10 of the Medicines Act so provides. And then the balance of Section 4.2 and following also dispenses with labelling requirements for compounded medicines, save that you have to provide in Regulation 5 the information specified in Part 2 of Schedule 26. And that is found at the back of these regulations at page 423A. anytime you make a pharmacy medicine, you at the least have to do the following. Where the product is administered to a particular individual, you have to provide the name of that individual, the name and address of the person who sells or supplies the product, the date on which it's sold or supplied, common name, directions, precautions under 8. 9, if the pharmacist in the exercise of professional skill is of the opinion that one of the more of the conclusions of 8 is inappropriate, they can be dispensed with, and then you can provide under 10 whatever you think is appropriate. There are bare labelling requirements applied to pharmacy medicines, and that's because they're all being supplied pursuant to a prescription. We'll see that when we come back to section 10. And now is probably an appropriate time to go to section 10. I'll come back to the rest of the HMR in a second. Section 10 is at tab 11 of this same bundle, at page 351. The restrictions imposed by Regulation 17.1, Manufacturing Authorization, and 46, Marketing Authorization, do not apply to anything which is done here. In a registered pharmacy, a hospital, a care home, or a health centre. So that's condition 1. Where is it done? Condition 2 is by whom? Is done there by or under the supervision of a pharmacist. So the gateway, the only gateway that's relevant for Article 3, and the only one that is relevant for Article 40, Paragraph 2 bis, is this. It's pharmacy only, pharmacy supervision only in certain specified premises. What can be done? Well, 10.1a permits preparing or dispensing a medicinal product in accordance with a prescription given by a practitioner. So any time that you're going to get into Article 3 or Article 4.2 bis, there has to be preparation in accordance with a prescription given by a practitioner. (10.1b) is not relevant to this case because it permits not preparing or dispensing, it permits only assembling a medicinal product, and that the guidance and the definition show is different to the types of invasive manufacture we're involved with, so it's assembly only. And then 10.3 is a strange provision. It provides those restrictions, that must be marketing authorisations, etc., do not apply to the preparation, same language, and it's preparation throughout all of 10.1 and following, preparation or dispensing in a registered pharmacy, and many hospital pharmacies are not registered pharmacies, of a medicinal product by or under the supervision of a pharmacist in accordance with a specification furnished by the person to whom the product is to be sold or supplied. And that can only be a pharmacist-specific implementation of Article 5 of the directive. It's to allow a pharmacist to make a special. So that is not involved in this case. And then the balance of the provisions about preparing stocks, etc., all required to be done in a registered pharmacy, and they're all about preparing. So those are the pharmacy provisions, and we say the only one that is of any relevance is 10.1a, because it is the only one that has any prospect of complying with the directive as interpreted by the CJEU in both Apposite and IEFA. Now, prepared does not embrace full-blown manufacture. And there's a couple of things I can show you to make that good. The first is paragraph 69 of Mr. Porter's witness statement, which is in Supplementary Bundle A, tab 4, page 81, citing MHRA guidance. Yes, Supplementary Bundle A, tab 4, page 81. Preparing a medicine, he says, is understood to mean
So
preparing.
where, I've got page 81, but where am I looking?
69 at the top, my lord.
Right.
Preparing is understood to mean preparing small quantities of medicine. That's confirmed by the MHRA and the RPS when proposals to amend and repeal the Medicines Act were consulted on in 2012.
Who is Mr. Porter?
He's my client's witness. You can see who he is, page 58. He's the business franchise head of ophthalmology at the claimant Novartis. His view doesn't matter. What the MHRA says in the context of... so what he quotes from is a MHRA document from the time of the review of the contents of section 10. The MHRA had originally intended to replace the term prepare with manufacture, since they considered it can cover any making of products. MHRA did not make the change in the end because it said as follows: following the consultation response from the RPS, there's a perceived difference between prepare, which is viewed as being done under section 10 exemptions, as opposed to manufacturing, which is undertaken under a specialist licence. The changes risk confusion of professionals and the public. Prepared and manufactured are currently understood to be different scales of production. The change risk, at least the change to use the word manufacture, risk blurring understanding about the volumes of production. So what you have is, as you would rather expect from a provision designed to implement a compounding exemption for retail supply, is the notion that it's reactive and at small scale to meet retail demand as it presents itself from time to time. And I'm going to show you in due course other guidance from the MHRA that says exactly the same thing, in particular in contrast to wholesale supply. So going back to the HMR, we've looked at Regulation 4. Let's just have a look at the rest of it, because it does operate to cast some light on some of the arguments made about modes 1 through to 4.
Remind us where the HMR is to be found.
It's Authorities Bundle B, tab 13, and I'm picking it up in the definitions at 8 at page 391.
Thank you.
So going through these definitions, there are a variety of interesting, relevant definitions. You've got the definition of administer. Administer to a human being means orally by injection or by introduction into the body or external application. And any reference in these regulations to administering anything is to administering it in its existing state, or after it has been dissolved or dispersed in or diluted with or mixing a substance used as a vehicle. So aliquoting is not administering as defined on any analysis. You then have the word assemble defined. In relation to a medicinal product or active substance, assembled means it includes the various processes of dividing up, packaging and presentation of the product or substance, and assembly has the corresponding meaning. So that's why 10(1)(b) of the Medicines Act doesn't apply. Biological medicine is defined by reference to the annex to the directive. We have the British Pharmacopoeia defined, and then very importantly, business is defined in the following NHS blind fashion. It means A, a professional practice, B, any activity carried on by a body of persons, whether corporate or unincorporated, and C, the provision of services by or on behalf of the Secretary of State, the Minister for Health, Social Services and Public Safety, Welsh or Scottish ministers, as the case may be, under the following enactments. So providing healthcare by the NHS is defined to be a business. Then turning on 394, you have the EU marketing authorisation defined as one granted under the regulation, European Pharmacopoeia defined, GMP defined, Health centre defined at 395. Hospital at 395 means a clinic, nursing home or similar institution. And then immediate packaging is defined to mean the container or other form of packaging immediately in contact with the medicinal product.
Thinking to myself, just been given all these definitions without any.
I'm going to show you why they're relevant, my lord, in a second.
Wouldn't it be better to do that when we get to the way they're relevant? If you've just been given lists and lists of definitions without even.
It's a fair cop, my lord. I can do it that way if you'd prefer.
Well,
Can I just?
if we're short of time, and maybe we're not. Maybe you're ahead of yourself. But rather.
Doing all right.
Okay. Well, do it your way. But I'm beginning. But
Well, there's only two.
take all these definitions in.
There's only two more I was going to show you, actually.
Okay.
There's manufacture, which means in relation to a medicinal product, any process carried out in the course of making the product, but does not include dissolving or dispersing the product in, or diluting or mixing it with, a substance used as a vehicle for the purpose of administering it. Now that's a very important distinction, because what comes after the but does not include is what is called in the jargon reconstitutive compounding. And a classic example of reconstitutive compounding is diluting Avastin with saline solution for the purposes of administering via the drip to the patient. That is reconstitutive compounding, because it is dissolving the product, Avastin, in or mixing it with a substance, the saline solution, used as a vehicle for the purposes of administering it. So manufacturing does not include reconstitutive compounding. By contrast, aliquoting is manufacturing, as defined. And we'll see that in the guidance. There are particular provisions about reconstitutive compounding. And then the only other definition I'd wanted to show you, two others. Outer packaging at 397 does what it says on the tin, forgive the joke. And then 400, registered pharmacy is defined as premises in Great Britain entered on the GPC's register. And indeed, I overpromised. Retail pharmacy business is defined at 401. It means a business which consists of or includes the retail sale of medicinal products that are not subject to general sale. And then at 402, there are various definitions at 2 to 4 that explain what is meant by a reference to wholesale dealing, etc. And then the last of these definitional things, forgive me, is 7 at 403. For the purposes of these regulations, medicinal products are of the same description if A, they are manufactured to the same specification, and B, they are in the same pharmaceutical form. Now, the significance of that will become apparent when we look at the wholesale provisions. Then 407, we have the manufacturing and wholesale dealing provisions. Let's skip over those actually. Let's go to the marketing authorization first at 412. At 409. Regulation 46, a person may not sell or supply or offer to sell or supply an unauthorised medicinal product. Sale or supply is not defined. It means what it says, it's any form of sale or any form of supply. A person may not sell or supply or offer to sell a medicinal product otherwise than in accordance with the terms of, so the terms of the marketing authorisation, a certificate of registration, etc. 3, a person may not possess an unauthorised medicinal product if the person knows or has reasonable cause to believe that the product is intended to be sold or supplied to another person within the EEA. 4, a person may not, in the circumstances mentioned in 5, manufacture or assemble a medicinal product, or B, procure the sale, supply, manufacture or assembly of a medicinal product. So these are comprehensive restrictions on any form of dealing in relation to an unauthorised product. There's a defence in 5 if the person knows or has reasonable cause to believe the medicinal product has been or is intended to be, sorry, not a defence, so the circumstances are that you know or have reasonable cause to believe that the product is intended to be sold or supplied contrary to paragraph 1.
This is the UK or possibly GB authorisation, implementation of Article 6.
Exactly, my lord.
So if there is ambiguity
You go back to the directive.
about the terms, you go back to the directive. I mean, it's quite common, I hardly need to tell you this, but in certain circumstances for us almost to overlook the regulation and go back to the directive and conduct the argument by reference to the directive because the regulation can't mean anything different. Just so that I can know when thinking about this, I'm not for the moment criticising you for taking us to the regulation. We've got to see it is the domestic legislation.
Yeah.
But do we get anything special out of Regulation 46 that helps in our understanding of Article 6?
You get, in my submission, when you go back to the domestic regulations, you get 3 things. You get precision by reference to the domestic context. You get an answer as to how the implementer views the particular domestic setup, for instance, the National Health Service, being addressed and falling to be withdrawn. That's obviously extremely helpful. You also get associated sanction, which is not provided, and that was what I was going to show you next, Regulation 47. And then the last thing that you get, and this is a really important thing not to lose sight of, is that you get the domestic rules that operate in those interstitial spaces that are left to national law by the directive.
Right.
And
I understand all that conceptually, but it's just helpful to know, as it were, whether there's something special we should be looking for when you're taking us through this. The answer is you'll tell us when there is.
Well, what I say is that when you look at sale or supply in the context of these regulations, the notion that somehow the regulations are intended to exempt the NHS from the operation of the directive is hopeless as a matter of domestic law. And that is a matter of domestic law, if EU law were to permit it, which it doesn't. But either way, it confirms NHS supplies can be wholesale, they can be retail, but they're supplies captured for all of the material purposes of the directive.
What you also get is an understanding of how this member state has chosen to, or the extent to which it's chosen to take advantage of any derogations.
Absolutely.
permitted.
That's exactly what I meant when I referred to the interstitial spaces. Obviously, that's most immediately applicable in relation to Article 3, Article 5 and Article 42 bis. But equally, it's also relevant when one asks how the apposite exemption or exception, if it exists, is to be treated as a matter of domestic law. Because, and my submission will be, what apposite does when its 2 conditions are met is seem to create some form of additional exception of the same calibre and character as the sorts of exemptions created by Articles 3 and 5. And therefore how the national law would accommodate that exemption is itself relevant. I hope that's clear. So those are the provisions implementing the requirement for authorisation. The rest of Part 5 then deals with how to apply for marketing authorisation. Let me then show you the provisions in relation to specials. They're at Regulation 167, page 412. They are extremely clear and prescriptive in fleshing out and implementing a regime of licensing pursuant to the national discretion created by Article 5. So this is all national law, this is not the directive. the medicinal products are supplied in response to an unsolicited order, etc., etc. Condition C, manufacture. You see, it uses the word manufacture here, not preparation or assembly. Manufacture and assembly of the medicinal product are carried out under such supervision, that is by supervision in A, I think. Record keeping obligations in D. And then G is material. Condition G is that if the product is distributed by way of wholesale dealing by a person P, who has not, or as the case may be, manufactured, assembled or imported the product in accordance with paragraph 6, P must be the holder of a wholesale dealer's licence in relation to the product in question. Now what that says in real language is, as a matter of the national discretion under Article 5, it is permissible to distribute the special through a wholesale dealer. There is no equivalent provision in relation to compounding. And the reason there needs to be such a provision, pursuant to the national discretion, is because, as you remember from the directive provisions I showed you, otherwise the directive requires all wholesale dealing to be in relation to products holding a marketing authorisation. So the only form of unlicensed product our UK scheme permits to be distributed by way of wholesale dealing are specials. That's the specials provisions. Then let's look at the manufacturing provisions.
Specials and not the Article 3 types. Is what you're saying.
No, and not and not the Article 3 type. Exactly, my lady. It basically means that compounding under Article 3 has to be for retail supply. (407) Manufacturing and wholesale dealing. You can see the detail at 408. A person may not accept, in accordance with a manufacturer's licence, manufacture, assemble or import from a state any medicinal product, or B, possess any medicinal product for the purposes of any activity in A. Nothing else applies in relation to that. And over the page, wholesale dealing.
Where are you?
I'm sorry, my lady?
Which page are you now?
408A it is. Regulation 18. So we've been looking at 17, which was manufacturing at 408. Then 18 is wholesale dealing. A person may not accept, in accordance with a licence, a wholesale dealer's licence, distribute a medicinal product by way of wholesale dealing, or possess a medicinal product for the purposes of such distribution. Paragraph 1A does not apply to anything done in relation to a medicinal product by the holder of a manufacturer's licence. That's the Article 77(3) exemption, or is subject to regulation but that is subject to regulation 19. And then 18.4, very relevant. In these regulations, a reference to distributing a product by way of wholesale dealing is a reference to selling it or supplying it, or procuring it or holding it, or exporting it for the purposes of sale or supply to a person who receives it for a purpose within paragraph 5. Paragraph 5, those purposes are selling or supplying the product, so that would be selling it by one wholesale dealer to another, or B, administering it or causing it to be administered to one or more human beings in the course of a business carried on by that person. And that's why I referred you to the definition of a business. What 8.4 and 8.5 make it absolutely plain is the following. Any supply by a commercial entity to the NHS is wholesale dealing. Any supply by a legally separate entity, Trust A, with legal identity, separate to the person it's supplying it to, Trust B, is wholesale dealing by Trust A. There is no free pass for the various different legal entities that form the NHS from the requirements to comply with wholesale dealing. And indeed, if you'll forgive evidence from the bar, it was because of the multitude of wholesale dealers' licences that had to be set up by the NHS that they created a special centralised NHS wholesale dealer to undertake distribution to end hospitals. So the NHS is covered by this regime just as much as any other hospital or private entity, and the regulations say so in terms. Then 6, a wholesale dealer's licence does not authorise the distribution of a medicinal product by way of wholesale dealing unless a marketing authorisation is in full force in respect of this product, but this is subject to the exceptions in Regulation 43.6.
Just give me 1 moment. I don't remember these regulations being referred to, let's say Regulation 80 being referred to by the judge. But she was referred to them, was she?
She wasn't referred to that particular regulation. That regulation was, I'm referring it to you because it responds to, first of all, paragraph 44 of my learned friend Mr. Locke's skeleton argument about wholesale dealing, and it also responds to paragraph 32.6 of my learned friend Mr. Peretz's submissions about looking at the whole distribution chain. And I will candidly admit that having looked at both of those, I looked back at these provisions and saw in them a reference to the fact that you cannot engage in wholesale dealing in relation to unlicensed products. And that is a highly material issue here, because my learned friend Mr. Peretz, on the one hand, says it is an unlicensed product, but not for the purposes of the marketing authorisation. You have to tease out what the consequences of it being an unlicensed product are for the scheme as a whole. Because on any view, when you look at Mode 3 and Mode 4, that is wholesale dealing. Indeed, that is my learned friend Mr. Locke's positive case in paragraph 44 of his skeleton argument.
So this particular line of argument was not developed.
No, it wasn't. But we wrote to Mr. Peretz in particular.
I'm not making any point about not taking anything. I just want to understand how this fits in to what I've understood to be the judge's reasoning. The answer is it doesn't fit in because she wasn't.
Absolutely. It's responsive argument, as I will show you when I get to those particular paragraphs.
Isn't it more than that? It's a substantive, isn't it?
Well, it is. It is. I can't escape the fact that once you've seen these provisions and you've seen what they say, which is you may not engage in wholesale dealing in relation to unlicensed products. If Mode 3 and Mode 4 are wholesale dealing, you can't engage in wholesale dealing in relation to CB. And that's a further answer to...
Well, it's Mode 2, isn't it?
No, it's Mode 3 and 4, because the wholesale dealing will be by the NHS Trust Hospital, let's say Liverpool for the sake of argument, that's making CB and then supplying it to, let's say for the sake of argument, Newcastle.
Because, I mean, the judge on this part of the argument constructed the argument entirely by reference to the language of the directive.
She did.
And the phrase placing on the market.
Yes.
And gave, and I don't mean this in any way rudely, because I would have done the same, a rather impressionistic answer to what could constitute placing. Surely this can't constitute placing on the market.
Yes. No, it's.
Your point. I don't want to give you a point I don't want to attribute to your point which is a bad point. But that's all beside the point, because even supposing that we're right under the directive, the way it has been implemented under the regulations.
That's right.
Makes it perfectly clear what this country has chosen to treat as placing on the market.
With respect, my lord, it actually goes further when you tease at it, because the directive itself says that you can't engage in wholesale dealing in relation to an unlicensed product. And I showed you the provisions in the directive that say that. And one of the inadequacies in the CJEU's case law is that all that's been looked at is the marketing authorisation and the manufacturing licence. When I spotted this point and we wrote the letter to Mr. Peretz, you go back and reread the authorities, there's nothing about wholesale dealing there at all.
And what is the letter to Mr. Peretz? You started to say something about it. But
Yes, we wrote a letter to the MHRA saying, effectively, we've spotted this point. Please confirm how it's consistent to engage in wholesale dealing in relation to these provisions.
But these provisions are not implementing a derogation.
No, implemented
So
the directive.
yes, they are, you may say they implement or they show how we have understood placing on the market, but placing on the market is an EU directive term and it must mean the same in every member state, and how we've implemented it must be construed with that in mind. mustn't
These
it?
provisions, my lady, are implementing the provisions that I showed you in relation to wholesale dealings. If you go back to the directive, what they're implementing is Article 76 and following. And you'll remember I showed you, and my Lord Justice Underhill asked me questions about Article 76.2, which says, in the case of wholesale distribution and storage, medicinal products shall be covered by a marketing authorisation granted pursuant to the regulation or the directive. All that the directive permits you to do is wholesale dealing in relation to licensed medicines. But anyway, to complete the chain, because the provisions
Yes,
cover...
but my lady must be right that in principle, subject to the point I'm about to make, Regulation 18 being made, no doubt, under the European Communities Act, can't give a wider meaning than is given by the directive. To which you say, well, that's fine. It doesn't, because Article 76. But perhaps there would also be an argument that, as you rightly said earlier, how the general language of the directive applies to, in the circumstances of particular countries, allows, I think what you call an
Yes.
interstitial area,
Yes.
and the internal workings of the NHS might be just such an area.
Yes.
And you're saying, because of the definition of business,
That's right.
Article 18, whether it is glossing or Article 76 doesn't really matter. It's something we'd be permitted to do in order to apply the directive to our circumstances.
Yes. And the
Have I
language-
got that right?
That's right, Neil, but there is a further point, which is that Article 76.2 is not formulated by reference to any concept of placing on the market. It simply says, in the case of wholesale distribution and storage, and I referred you to the definition at 117 of the directive, and it falls within that, medicinal products shall be covered by a marketing authorisation.
But a marketing authorisation is only needed if you are placing it on the market.
If you are intending to place it on
Well,
the market.
if you're intending, because that's what Article 2.1 says.
Yes.
But are you saying that the definition of wholesale or wholesale distribution might include some activity which is not within the definition of placing on the market? I don't see how that can be the case if you've
No.
got to have a marketing authorisation
What
in
I'm
order
saying,
to have a wholesale licence.
what I'm saying is something quite different, my lady, which is whether or not you are, pursuant to the apposite analysis, released from the obligation to have a marketing authorisation, and only a marketing authorisation. When you come to look at the wholesale dealers provisions, all that you are permitted to do as a wholesale dealer is deal in relation to licensed products with a marketing authorisation. The only exception to that is Regulation 167, whatever it was I just showed you, which says you may do so in relation to a special 2, and that's a national provision. There is nothing that enables you to engage in wholesale dealing in relation to anything that is an unlicensed product. And obviously the process of wholesale dealing is part and parcel of a process of supply, sale of supply to the eventual market.
You can wholesale T-shirts.
Yes.
Right. What we're talking about is and you don't need a marketing authorisation for that. What we're talking about is the wholesaling of products which are subject to a requirement of a marketing authorisation before they're being placed on the market. This wholesaling regime doesn't cover every product. It only covers medical products. It only covers medical products which are required to have a marketing authorisation.
What I'm going to show you, my lady, in due course when we come to looking at the apposite case, is that the CJEU was insistent that not only that you have to meet the two apposite conditions to get you out of having a marketing authorisation, you also have to meet the Article 42 bis exception from having a manufacturing. And the condition that they imposed in relation to that was that it was in accordance with national law and it was for retail supply. So there is nothing from apposite that in any way invalidates the operation of the wholesale provision.
No, but if you meet the apposite criteria, whatever they are, and you are not then within the marketing directive, you don't need a wholesaling licence to sell the product. That must be right.
If you meet the apposite criteria, let's say you make 10,000 batches or 10,000 doses, pursuant to agglomerated 10,000 prescriptions, and there is, for the sake of argument, no modification. We'll come on to that in due course. You are still, in substance, if you are supplying those medicines to an NHS trust hospital for their administration of the medicines to their patients, you are still engaged in wholesale dealing as it's defined in our domestic regulations.
And you say in Article 76.
And in Article 76. And the plot thickens when you look at Regulation 43, which is the final nail in the coffin, because what Regulation 43 does is it expressly addresses the situation where there have been changes, because it says, in terms of the obligations of the licence holder, the licence holder must comply with the guidelines on GDP published by the Commission. I haven't showed you those. They say in terms, the GDP guidelines, that the identity of the product must be respected. In other words, you can't change the nature of the product at all whilst the wholesaler. I can show you that in due course. And then at 43.5, subject to paragraph 6, the licence holder must not sell or supply a medicinal product or offer it for sale and supply unless A, there is a marketing authorisation in force in relation to the product. That must then ask, is there a marketing authorisation for that product? The answer is no, there is not. But let's assume against my argument that you say, well, an apposite marketing authorisation suffices. You've still got B, the sale or supply or offer or sale of supply is in accordance with the authorisation. Well, that is most certainly not the case, because the authorisation for Avastin is to supply vials of a certain volume and size for the treatment of ovarian cancer, whereas what is being supplied is not in accordance with the authorisation. It is a pre-filled syringe for the treatment of a completely different indication. And there's no amount of juggling that you can do to get around that language. So the bottom line is you get to a position where wholesale supply of apposite type medicines is impossible under our domestic regime. That is entirely consistent with the EU regime. And when you look back at the case law, it's also entirely consistent with apposite and IEFA, which merely sanction retail supply. And this goes to the point. This goes to the point you asked my learned friend, Miss Stratford. At the end of the day, the policy is designed to create a massive demand for CB. 12,000 units simply at this particular location. And it's obvious that if this policy proves to be lawful, it's going to be taken up by other CCGs. There's been all kinds of threatened look-alike policies in relation to this. This is why this is such important test case litigation. And what you're going to be moving to is potentially a situation of bulk supply being concentrated in the 3 or 4 manufacturers that actually have the wherewithal and the facilities to even begin to engage in this compounding operation. And to describe their supplies of tens of thousands of doses, even if it is in relation to prescriptions, as being anything other than wholesale supply, is contrary to reason in this respect. There's no exemption in the regulations that say simply because you have a prescription, it then doesn't amount to wholesale dealing. Anyway, those are those provisions, and I entirely take on the chin the point we didn't raise these provisions with the judge below. We've missed them. I saw them in consequence of reading through and thinking about my learned friend's arguments, and that's why we wrote. And if there's a criticism, it should be directed at me for not having made an application to amend, if you think that's what it is. But we're here to work out whether this supply is lawful. And in my submission, that point can't simply be brushed under the carpet if it's a real concern.
I'm sorry, not to rub it in, but just to make sure that I didn't properly take this in when I was reading. This is in your chosen argument.
No, it isn't.
Any of your chosen arguments.
Why we wrote. To be fair, my learned friend Mr. Locke has raised certain concerns with the MHRA as well by way of his letter. We're here trying to ventilate the legality of these supplies.
Well, nobody's making any point about it at the moment.
I'm sure they will.
I'm just trying to understand what the factual position is. Okay.
You're not going to. Mr. Peretz very kindly indicates he's not intent on taking a pleading point because we're here to get to a position. We're here to get to a position where the MHRA can ultimately give guidance that informs everyone as to what the law is. Because that's what they promised to do in consequence of this hearing. So I don't know if that's a convenient moment.
Well, I think if you felt you were going to be tight with time,
carry on.
Let me finish. If you felt you were going to be tight with time, then I wouldn't say let's go on to 4:30. If, as when I asked you this question 20 minutes ago, you said you were quite comfortable with how quickly you were going, then we'd be happy to rise now. It's been quite a pounding afternoon.
I'm sure you're bored to the back teeth of my voice already and welcoming Miss Dretford back at open arms at the earliest available opportunity tomorrow. But can I just show you a couple more documents because there are a couple of things that I think we can usefully look at. MHRA guidance. Now, one of the peculiarities of this case and the concerns, and it must be a concern for the court ultimately, is once you take this out of the relevant conventional licensing system, who is actually regulating the products to ensure that the products are made so that they are safe? And we had a bit of a debate with the judge. My learned friend Mr. Locke's evidence suggested that the relevant regulator was the CQC. It turns to the Care Quality Commission, which inspects hospitals and ensures that the care in hospital is adequate. It turns out that, in fact, the relevant regulator for NHS pharmacy compounding operations is a body, and I use the word regulator in the very loosest sense, a body called NHS Special Pharmaceutical Services.
Yeah, well, I see that's where Mr. Kelly's evidence inquiries ended up. It'd be quite useful just to know from Mr. Locke, irrespective of any point about admissibility and so on, is that itself a disputed point, that the relevant oversight body, to use a non-technical term, is the NHS whatever it is?
SPS.
I don't wish to sit on the fence and transfer the matter like a sort of hot potato from learned friend Mr. Peretz, but my clients are clinical commissioning groups. They have been attempting to find their way through this process. They have been treated by the claimants below and by the appellants as if they're all-purpose representatives of every facet of the NHS. They're not. They're 12 small clinical commissioning groups, and they're trying to do their best to respond to a whole series of questions which are essentially about how hospitals are organised.
So you're about to stick the question on to Mr. Peretz.
So I think, my lord, my lady, we've done our best, but it's not within our sphere of expertise at all.
Well, yes, but then you're issuing a policy which the appellants say will lead to widespread use of this compounded product. And what you're saying then is that they have issued that policy without knowing who is responsible for supervising that compounding process and making sure it's carried out safely.
Well, my lady, it's not quite as simple as that. We have issued the policy having looked very carefully at how the present market works. And you've seen all the material about the operation of the present market. We've also issued the policy having made inquiries of very substantial hospital trusts who assured the CCGs that they're in a position to be able to provide the material safely. How those particular pharmacy operations are regulated, just in the same way as how oncology services that we commission are regulated, or orthopaedic services are regulated is essentially a matter for the specialists doing the oncology or the orthopaedic. As far as the clinical commissioners groups are concerned, if entirely respectable large hospitals are doing this and assuring us they're doing this properly, that's what they rely on. That doesn't mean that we're not going to try and assist the court as much as we can. Of course we will, but essentially we start from the point of view that's not.
Yeah, well, you've made a fair general point. It could, however, be said that we're not only talking about what you should have considered before you had issued the policy, but also what forensically, having a specialist team, both of solicitors and counsel in this area, you could help us with. But if you don't know the answer,
Well,
fair enough. Let's see if Mr. Perrotts does.
As far as I'm aware, my lord, subject to those caveats, we now understand, and this is an issue which has only emerged after the trial, we now
Quite understood,
understand that the NHS Specialist Pharmacy Service does do inspections, and there is a memorandum of understanding between the Secretary of State and NHS England, which provides for that.
Thank you. That's very helpful.
That's the evidence which we tried to introduce.
Well, I dare say, Mr. Perrotts, you represent the Secretary of State, which is closer to representing the NHS insofar as there is a single such entity. Do you have anything to say upon this question? Perhaps I shouldn't have been part of it.
To be frank, I've just been passed a note, and rather than try, which I'm not entirely sure I followed, but rather than try and make sense of it now, I think we will simply, we can either.
Sorry, this was a misguided attempt by me to find out whether this was common ground.
Protracted, I don't know. I think it's what.
It was a bit better than that, but anyway, yeah. We'll get
Can
to
we
the-
start with what we know, my lord? And
Well,
I'll
I think perhaps we should now bring matters.
Can I be really cheeky and say to speed my submissions tomorrow, the first document I'm going to be referring to is the GPC guidance in Sub A, tab 18, on the quality assurance of aseptic preparation standards. This is the professional guidance that binds all pharmacists, whether or not in the NHS.
Well, give us the reference again.
It's Sub A,
Yeah.
tab 18, and the particular passages I would invite you to read are chapter 1, which is very short, it's a couple of pages, chapter 4, which sets out what is required by way of prescription before you start compounding, chapter 6, which is the shelf life and formulation stability, and then the excerpts in here from chapter 10 and 13. I'll guide you
Between myself, we will take the bundle away with us. I make no promises as to whether
Understood.
we will read it overnight, but we will tell you whether we have or not.
I'm grateful.
Very well. 10:30 is okay.
Oh yeah, about halfway through my note.
Ian, turn it off. Never turned it off.